I want to thank everybody for coming today and attending this hearing on the 15th anniversary of the Family and Medical Leave Act that we'll call FMLA. This legislation establishes a minimum labor protection to help working people balance their work and their family lives. FMLA has been in the works for many years and had been before it was passed. And I'm delighted that Representative Pat Schroeder, the mother of FMLA, is able to be here today to testify before us. Welcome, Pat. There's no question, Representative Schroeder, that you worked tirelessly on this benefit for working families so that we all know that your testimony is going to bring us up to date of where we've been and where we have yet to go. The USA should be a leader in the world on these matters. Our United States of America, funny, we're not quite, we're not close, but we have a lot of work to do. But at the current time, because we lag far behind other countries in providing family-friendly policies, such as paid leave to our workers, we need to catch up, and we need to catch up fast. However, in the 15 years since FMLA was passed, there has been some good news. Millions of workers have been able to utilize leave to care for the birth or adoption of a child. Hear that one over there. Or to care for a sick child or a sick parent, or to care for their own serious medical condition. Shante Lasco will testify today about her leave, why it was good and how it could have been better. There are also many good employers, although not nearly enough, in this country who realize that family-friendly policies actually help, not hurt, their bottom line. And just this year, on a bipartisan basis, we passed the first ever expansion of FMLA. And I'm really proud to say that the expansion is the result of legislation introduced by Senators Clinton and Senators Dodd and myself to provide additional leave for workers to care for seriously injured service members. The genesis of this legislation was the Wounded Warriors Commission, chaired by Secretary Donna Shalala and Senator Bob Dole. The commission recommended an expansion to FMLA because it understood that workers with family members in the military face additional challenges due to the conflicts in Iraq and Afghanistan, which have resulted, and we know that, in over 4,000 deaths and more than 30,000 injuries, with many service members being seriously injured mentally and physically. The new expansion provides these workers job-protected leave for up to 6 months so they can care for their wounded family member who have, as we know, sacrificed so much for this country of ours. This is important because for the first time, family members other than the spouse, parent, or child can take off leave under the Family and Medical Leave Act. In addition, the law also incorporates an important provision authored by Representatives Altmaier and Tom Udall from the House that extends the 12 weeks of leave to families of service members who are deployed overseas for matters arising from their deployment. Many members of the House and Senate are submitting comments to the Department of Labor on how to implement this expansion to FMLA. Assistant Secretary Lipnick is here today, and I have to welcome you back because the Secretary Lipnick actually was a staff person working for Leader John Boehner when he was on was the chair of this committee, and this is her first time being on that side of the table, so we'll be kind of nice to you. And I'm sure Joe really will, and we all will, because this is a really nice committee. But we welcome you. But at the same time, we hope that you'll and the department will heed our suggestions to interpret the law in the broadest possible way so that it can be administered as intended, because although we're pleased to be expanding the military families' leave, work on behalf of all working families is far from completed. More employers need to step up to the plate, and we need to enact other workforce protections that establish our country as a leader in this arena. This includes passing legislation providing for paid sick days, paid leave, equal pay for women, and other necessary benefits for working families so they can bridge work and family, not have to choose where their allegiance is, at home or at work. They need not to make that choice. They need to be in both places, and we need to help them. That's why I've introduced the Balancing Act, which puts into place a whole host of family-friendly policies, such as paid family medical leave, benefits for part-time workers, and additional leave for parental involvement activities, including attending routine medical matters. Senator Kennedy and Representative DeLauro have introduced the Healthy Families Act, which will provide workers with 7 days of paid sick leave to care for their own medical needs or the needs of a family member. That's why Representative Bishop, a valued member of this subcommittee, along with Senator Clinton, has introduced H.R. 2744, the Airline Flight Crew Technical Corrections Act, which amends FMLA to make flight attendants or crew members eligible for FMLA if they have worked 60% of the employer's monthly hour or trip guarantee. I'm pleased that Jennifer Hunt, a flight attendant, is here to testify in that regard today. By telling her story, she will show us that it is very important to provide job-protected leave to others in her same position. Lastly, let me say just a few words about the Department of Labor's proposed regulations to the FMLA. I was disappointed that without scientifically sound data, the Department is proposing changes that will make it somewhat harder, if not a lot harder, on the workers and make it harder for them to utilize FMLA leave. I was a human resources manager, and I'll remind you of that throughout this hearing, for nearly 2 decades. And I know all about the issues that come up when workers need time off from work to care for family matters. Over those years, it became very clear to me and the employers I worked for, that it was important to help workers with these issues, because we knew that when a worker's family life was in order, he or she was a much more committed, loyal, and focused employee. So it was in the best interest of my companies, the ones I worked for, to give workers the leave that they needed. And these proposed regulations are a bit disturbing to me because they shift that balance more in favor of the employer than it was in the past. So unlike the Fair Labor Standards Act, from which the FMLA was modeled, these proposed changes will allow a worker to waive his or her right under FMLA without the supervision of a court or the Department of Labor. And they will create more hoops for the worker to jump through in order to utilize a right to leave that is already enshrined in law. Notice will have to be immediate and contain detailed information about the need for leave. And under the proposed rules, an employer and not the employer's doctor could talk directly to the health care provider about the worker's medical condition, or the worker could be denied leave. So these are just a few of the problems with the proposed rules. I and other members look forward to hearing from Assistant Secretary Lipnick on why the delicate balance that we have been able to achieve for 15 years needs to be upset at this particular time, when really what we need to do is be expanding FMLA and making it more positive for the workers. We're looking for fairness. We're not looking for obstacles for workers. And we're here today to talk about that, and I'm looking forward to hearing from all of you.